Just gonna see if I can fix my name, but it doesn't matter that much. So I guess I'll forget about the name thing. I can introduce myself anyway. You asked me to moderate the panel, which is pretty simple, especially online. We've got 15 minutes each, and then there's 15 minutes for Q&A.
That will be great, actually.
Great. And we can just follow the order that's set out in the program that you sent.
It's up to you, really. You can change if you want.
Sure. No, I think it's fine. The thing that can sometimes be hard when we're online is giving a bit of a hint about the time running out, because sometimes you can't see the chat. So probably the only thing that's possible is for me to say 2 minutes. So I'll just say 2 minutes. Have we got other panelists now? Nazia, you're present. Let me bring up the program as well. I have it here. So we've got first it's me, and then it's Dr. Evrim Durmaz. Maybe it's good for me to go through some pronunciations as well. I don't want to do a bad job. I see. Okay, ED, Evrim Durmaz. How do you say it?
Evrim.
Evrim.
Evrim Durmaz.
Evrim Durmaz. Dr. Evrim Durmaz. Great. And do we have Dr. Şanser Vurgun as well?
Yes, he will be here.
Or it's just okay.
Just a minute.
On the same link. Okay. Maybe it's nice to say the universities that you're representing. Where are you based?
We work at Muğla Sıtkı Koçman University. Muğla University.
Does anyone else feel like the audio goes a bit in and out for Evrim?
No, it's okay for.
It's just me. Okay. So what was the name of the university?
Muğla University.
Muğla.
Yes.
Muğla. Okay, so you're next, and then we've got Dr. Üyesi Ebru Demir.
Yes, I'm here.
How was my pronunciation?
Perfect.
Okay.
Really?
You don't have to be nice.
No,
okay.
It's really good.
Okay.
Yeah.
Great. I'm just getting my dashboard good here so I can flip between screens better as well. Üyesi Ebru Demir. Should I call you? You said Ebru just now. Is that your
Ebru? Yeah.
your preferred?
Name? Yes. Just Ebru. Fine. Yes.
Or is
Yes.
Üyesi your first?
Ebru is fine.
Okay. So should I say Ebru Demir then?
Yeah, like to introduce.
Now it's good.
To introduce, you can say Ebru Demir, but to refer, you can use Ebru only.
Yeah, fine. Ebru Demir. And what's your university?
I am at Ankara Yıldırım Beyazıt University. Ankara Yıldırım Beyazıt. It's a bit difficult.
Could you write it in the chat, maybe?
Yeah, that's not a bad idea. That's not a bad idea. Otherwise, all of you can do that actually.
Okay.
Also for you, Nazia. And I've already Google translated Soru-Cevap Q&A. So we've got that. Good. Yeah. No, but I'll do my best with the Nazia Dirigil.
You can only refer me with my name because my name even is a difficult task in my own language. So Nazia is fine.
Okay. We'll do that. Beyazıt University. And Şanser Vurgun has Vurgun has joined. Hi there. And I didn't introduce myself. I'm Matthew Scott from the Raoul Wallenberg Institute in Sweden. So thanks so much, Berkant, for the invitation as well. I wish I could join the other panels, but it would be meaningless. Maybe in a couple years, or maybe just a year, when the AI translation gets better, it'll be possible. I'm confident of that. But for now, we'll stick to this panel. And Berkant, since we've got a couple of minutes, I got the sense from the email exchanges that we had that this conference as a whole, it's sort of all connected to the earthquake. Is that right?
Yeah.
Or is it broader environment and...
Our aim is mainly focus on general environmental issues, but due to earthquake mainly in Malatya, Turkey, this conference mainly focus on earthquakes, actually.
Right. Yeah. I'll keep that in mind, just even for my own presentation. So, I mean, I don't know anything in any depth about the terrible earthquake that happened, but some of the standards and guidelines and reflections from other contexts are relevant, probably.
I think if you want, we don't need to wait until 12:15. It's up to you, really.
I'm good.
Okay.
If everybody's ready to go, then we can dive in.
Before we start, can I ask some of the technicalities? Because I'm quite bad at these technicalities. I don't know how to share PowerPoint. Could someone help me right before we start? So maybe I'm going to take your time. Is this arrow showing up saying that show now? Okay.
I think you just need to click the third button.
Okay.
If you have any problem, you just send an email to me and I can share the screen with you. Okay? No problem.
We can... I just started sharing now, and maybe it's okay if I have that on so I don't have to think about it when we're going as well. But can everyone see it?
Yeah, actually.
Okay, good. I think probably I'll lose sight of everybody if I put it in presentation mode. Can you see me while I'm speaking?
Mm-hmm.
Okay,
Yeah,
I can't see anything, but that's fine. I'll come out of it first. It's probably better if I don't have the PowerPoint when we open the panel. So I'll stop sharing and then try to be swift when I open it. Now I've stopped and I've got this. I'm not going to say people's universities because I'll do a bad job. So I'm just going to introduce people by their names and something about the title. And I'm just going to move that over. And yeah, give me 1 second to grab my phone to do timing. And we're ready. Great. Berkant, let me know when have we started already?
I think we can start. I just want to mention that we will be recording this session and planning to stream on YouTube if you do not have any problem with this.
No, that's good. Yeah, So shall we commence?
Yeah.
Okay. Great. Well, now we're on, and we're in the session looking at environment and international law in English. Thanks for accommodating and thanks for the invitation. I'm Matthew Scott. I'm leader of the Human Rights and Environment thematic area at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund in Sweden, and associate professor of public international law at the Faculty of Law at Lund University, which is just across the road from the Raoul Wallenberg Institute. And I've got the honor of being the chair of the panel today. So I want to, I also have the second honor of having the opportunity to present some of the work that I'm doing together with colleagues at the RWI. So I'm both a moderator and a panelist. So I'll keep my moderating short, but I want to introduce the other colleagues on the panel just briefly. They can say more about themselves when they open up. But in addition to my own presentation on international law and climate-related displacement, we have Drs. Evrim Durmaz and Dr. Şanser Vurgun, who'll be talking about marine pollution caused by armed conflicts in international environmental law. Then we have Dr. Ebru Demir talking about the notion of state responsibility after the judgment of the KLİMASENİORİNNEN case in the European Court of Human Rights, followed by another intervention relating to environmentally displaced persons by Dr. Nazia. Without further ado, I'll kick off. And what I want to talk about today connects to an extent, I think, with part of the impetus behind the conference as a whole, the phenomenon of the earthquake that struck Turkey, but it relates to broader issues around addressing the displacement dimension of disasters and climate change. This is an issue that I've been working on in different contexts for the last 12 years or so. First, looking at the situation of people who cross international borders in the context of disasters and climate change, so colloquially referred to as climate refugees, although the phenomenon is much more complex than that. But for the last 7 years or so, I've focused predominantly on the internal dimension, people who move within their own countries, and that might be short distances or longer distances for shorter periods of time or longer periods of time. But whatever the case, the approach that I consistently take is a human rights-based approach. So what I would like to talk about in this short time is what that approach looks like, and maybe to point to some other sources if you're interested in this kind of approach and want to know more about it. So the starting point when we think about internal displacement of any kind is the guiding principles on internal displacement. This is the non-binding document that is the result of extensive consultation led by Dr. Francis Deng, commissioned by the UN Secretary General in the 1990s. The 1998 guiding principles consolidate international human rights law, international refugee law, and international humanitarian law so as not to create new law, but to articulate how existing standards apply in this particular context of internal displacement. And human rights comes out as providing substantial guidance, especially in relation to displacement in the context of disasters and climate change. And the first distinctive contribution is what you can see on the screen now. It's a very simple contribution, but it helps to structure an approach both to the development of legal and policy frameworks, as well as more operational interventions in particular situations of disaster, displacement, risk. And it's a simple temporal distinction. So we have measures that states as the duty bearers should take to prevent and prepare for displacement, measures they should take to protect people during displacement. That includes during evacuation and throughout displacement, whether people are in temporary shelters, maybe they're sheltering with family members or neighbors, and so on. And then this final dimension of facilitating durable solutions. So the need to take steps to address issues around resolving the predicament of displacement, to the extent that people's experience is no longer characterized by being displaced. So that's what I'm going to talk about a little bit in the next coming slides. What I use in the work that I do with the Raoul Wallenberg Institute on disaster and climate-related internal displacement is a framework that has developed over the last 7 years. And it found its first articulation in this background brief that I've highlighted on the screen. There's also a link to it. The background brief on key international standards and guidelines relating to displacement in the context of disasters and climate change is structured according to that framework set out by the guiding principles on internal displacement. So it looks at prevention and preparedness, protection during evacuation and throughout displacement, and durable solutions. But it's not limited to those 28 principles that are contained in the guiding principles. It also integrates other international standards and guidelines, for instance, from treaty monitoring bodies and special procedures mandate holders, the special rapporteur on the rights of internally displaced persons, for instance, the CEDAW committee, who has produced guidance on the gender dimensions of disaster risk reduction and climate adaptation, as well as operational standards and guidelines. And here I refer to documents like the Sphere Standards, which is an extensive list of measurable standards that connect to rights to health, rights to shelter, rights to food, and a few others in emergency situations. So the Sphere Standards are integrated because they expressly adopt a human rights-based approach. They are designed to help practitioners respect, protect, and fulfill the rights of people in emergency situations. In addition, the Interagency Standing Committee guidelines on the protection of persons in situations of natural disasters, issued in 2011, also expressly adopts a human rights-based approach and was supported by the then Special Rapporteur on the Rights of Internally Displaced Persons as a way of operationalizing the guiding principles on internal displacement in a disaster context. So there's been thinking for a few decades around how to address something's happened to my audio. Let's turn that off. Can people still hear me?
Yeah, we can hear you, Matthew, but your slides cannot move, so we cannot see the next slides, actually.
The slides are not moving at all?
Yeah, no, it's still in the first one.
That's not so good. You haven't missed much, but I will... can you see them better now?
No, you're not sharing your screen right now.
Okay, let's see. I'll try and share again and not put it in sharing mode. How's that? Can you see climate change, disasters, and internal displacement?
Yes,
Okay.
actually.
So you haven't missed anything really. You just saw that one, I hope. And then we got to here, which is where I was talking about the guiding principles, the guidance from treaty monitoring bodies, and the operational standards and guidelines, and giving you a link to this document, which consolidates them into about 30 pages instead of several hundred. So it's meant to be of practical utility. So having gotten to that point, and not wanting to take more than allocated time, I'm going to just mention in the next, what I see as 4 minutes, some of the work that we've done at the Raoul Wallenberg Institute, trying to implement this human rights-based approach to climate and disaster-related internal displacement in different contexts. And hopefully you've seen my slide shift. What I'm highlighting here is one of the earlier outputs of our 2017 to 2023 Regional Asia Pacific program on human rights and sustainable development, where a lot of this early work was done. And part of the process involved collaborating with university colleagues in 10 countries around the region to test out this human rights-based approach to law, policy, and practice in a variety of country-specific contexts. So you can see the contexts. I won't read through them. It's basically the titles of the chapters in the edited volume. Unfortunately, this volume is not open access. A second volume produced by other members of what became the Asia-Pacific Academic Network on Disaster Displacement. That second volume is open access, and I can put a link to that in the chat. That takes also an interdisciplinary human rights-based approach to a variety of forms of human mobility, not just kind of sudden onset disaster displacement that we talk about in this book. Now, I'm jumping backwards for a second. I mentioned this background brief, which consolidates standards relating specifically to displacement. But over time, as we understand internal disaster and climate-related displacement as being a sustainable development challenge, work has continued to integrate more standards from a wider range of sources. And this took place through a number of collaborations over the years. And what we now use in both research initiatives as well as capacity strengthening and capacity bridging contexts is called the FIRE framework. So this is sort of an expansion of the approach to consolidating standards and guidelines, but now providing this kind of more structured framework for developing research questions, but also for supporting operational actors in analyzing their own contexts from a human rights-based approach. So that could be specifically on displacement risk, but it could also relate to wider questions about climate adaptation and disaster risk reduction. So right now we have a collaboration with Armenia and Georgia, where we're working to collectively analyze climate adaptation challenges around water in particular from a human rights-based approach using this FIRE framework. And last year we worked with local authorities in Kenya, Uganda, and Sierra Leone to look at urban displacement risk in the context of disasters and climate change, also using this FIRE framework. So we've developed a kind of curriculum that is a jumping off point for a variety of operational actors to use their own situational knowledge within a framework. So it promotes this multi-level, multi-stakeholder, multi-sectoral engagement with the complexities of internal displacement risk. And I think I'll share the slides here. I'm not going to talk about these. It just gives a bit more of depth into some of the kinds of considerations that emerge when we think about these dimensions of preventing and preparing for displacement, protecting people during evacuation and throughout displacement, and facilitating durable solutions linked to this FIRE framework and to the also consolidated standards and guidelines specifically relating to displacement in the context of disasters and climate change. So on that note, and hopefully sticking to my allotted time, I close there. We have time for Q&A at the end. So without further ado, I would like to pass the floor to Evrim and Şanser. The floor is yours.
Thank you, Professor. I'm going to try to upload our presentation right now. Okay. Can you see our presentation right now?
Not yet.
Not yet. Okay. I cannot share this one.
You could try and email me. It seemed to work when I shared mine.
It's okay, really. It's not that.
Or you can go without.
Okay. Hello again. First, we would like to thank the organizers of the symposium for giving us the opportunity to make this presentation, and also Professor Scott. We are both lecturers at Muğla Sıtkı Koçman University, and my research, sorry, for a second. My research field is actually general public law in general, and so I am going to make a presentation a little bit different from international lawyers. But I studied rights of nature at my PhD, and my colleague Şanser Vurgun, he's also a lecturer, and he studies his research field is international law, but also he studied sports law at his PhD. Here our study aims to critically examine the insufficiencies of so I cannot do this, but my colleague will make this presentation, so it's okay. Of international environmental law in protecting marine ecosystems during armed conflicts. So I'm going to open also my chronometer. I will begin by presenting our critical perspective on international law and its underlying reasons, followed my colleague's presentation on the positive law perspective. Capitalism as a system that shapes the framework of modern law and emerged in the 16th century has largely relied on the wealth extracted without cost from nature. Animals were hunted for commercial gain, and continents such as Latin America and Africa were colonized for their mines and other natural resources. This accumulation laid on the groundwork for the Industrial Revolution. The consequences of this accumulation process, whether through war or other means, have resulted in significant ecological destruction. Capitalism reliance on the exploitation of nature has fostered the adoption of anthropocentrism, which posits that humans are superior to the natural world, natural beings. However, in the industrial era, capital, not human beings, has become the center point, so we call it capitalism right now. The exploitation of natural resources has historically fueled conflicts. There are two perspectives in the relationship between war and nature. The acquisition of natural resources is a significant motivation for wars. During time of crisis, war serves as a means to address these challenges within the system. Conflicts over new raw materials, new natural resources, and market shares often lead to conflicts, which in turn generate economic activities. So a system can can overcome this crisis during this time. Secondly, wars result in the destruction of nature. Particularly following the Industrial Revolution, advancements in the weapon technology have led to levels of devastation capable of destroying entire ecosystem. A significant portion of these destructions occurs in marine ecosystems, including pollution from sunken ships, oil spills, and the introduction of invasive species. Furthermore, underwater explosions can kill marine life during the shock waves they generate. The most recent example of this impact of armed conflicts on marine environment is the ecological destruction in the Sea of Azov and the Black Sea. For instance, mass dolphin deaths have been reported as a result of explosions in the Black Sea during this war. There are several differences regarding the effects of armed conflicts on marine pollution. First, the destruction caused by armed conflicts at sea is not as visible as the destruction on land, and therefore often overlooked. Anthropocentrism, this kind of view, leads to a fragmented view of the world. The value of the interconnected life networks on the earth is not known. Therefore, the destructions in the seas cannot be fully understood in terms of their effects on other parts of the earth and people. Seas are not just water. Marine ecosystems contain a wide variety of animals as well as sea grasses, etc., that are really essential for life on earth. And other thing, destructions in the seas and oceans also affect species on the coasts. Chemical contamination in marine creatures consumed as food by humans, such as fish, can be transferred to humans, of course. All these destructions are long-term and often long-term, and elements such as sinking ships affect marine ecosystems for decades. And what about law? What about modern law? Modern law has been assigned a role in regulating the relations of people with nature and other people and states with each other. Accordingly, law should prevent conflicts between individuals and groups and protect the environment. However, the law is not fully effective in preventing ecological destruction in general because, like other modern institutions, modern law is also anthropocentric and focuses on economic needs. Even though there are environmental regulations in both national and international legal systems, protective regulations can be put in the background when environmental protection touches the essence of the economic system, the functioning of the economic system. Apart from this anthropocentric and economic-focused structure of law, there are also, we can say also something about environmental law. Although international environmental agreements accepted as binding by states generally have clear statements, their obligations to prevent environmental destruction are generally weak and insufficient in practice. This weakness may arise from the uncertainty in the language used in the contract or maybe scientific determination of the problem. They may not create the desired legal binding on the state. On the other hand, the right to make reservations about the contract will also result in the environmental protection target will not be achieved. Environmental law is relatively a new branch and continues to develop. Because it's in development, its borders are more flexible than other branches of law. Environmental legislations and decisions are increasing. The increase and strengthening of environmental regulations is parallel to the increase in illegal activities within the current system. And environmental law has made only small gains to this day. Large-scale environmental regulations have not caused much change for decades, and the destruction of nature has continued almost uninterrupted. States seem to have determined the boundaries of international environmental law. States have the authority to dispose of their own environment and natural resources, in theory, as they wish. And international law is obliged to operate in accordance with the sovereignty of states. But this does not affect the state's responsibility for the environmental impacts it will create outside its own country, of course not. Okay, I'm going to finish. Despite the principle of sovereignty of states over their natural resources, which is one of the principles of international environmental law, most of the savings on the Earth's natural resources belong to companies, especially in countries where the free market is so strong. In conclusion, while international environmental law attempts to address the ecological impacts of armed conflicts, it remains limited. However, as the law continues to evolve, there is hope for stronger protections in the future. And now my colleague will present.
Dr.
Şanser.
Vurgun, yeah, we can't hear you, sorry.
Yes. Okay. I would also like to thank the organizers of the symposium for giving us this opportunity to make this presentation. The concept of armed conflict is often employed as a substitute for war, particularly within the context of Geneva Conventions. The principles of armed sovereignty and the right to self-defense are explicitly prohibited by United Nations Security Council resolutions. In scenarios involving two nations and armed conflict, all affect entities, including marine environments, come into play. Therefore, it is imperative to discuss the implementations of international environmental protection during these conflicts. Initial steps toward international environmental legislation were taken through global collaborations, primarily spearheaded by International Maritime Organization. The impetus for these measures largely stems from incidents attributable to maritime activities and hazardous systems they support, often resulting from accidents and negligence. This international endeavor commenced officially in 1954 and continues to evolve. Subsequent agreements have incorporated concepts of cooperation and mitigation, with the most notable being the Hong Kong International Convention on the Safe and Environmental Sound Recycling of Ships in 2009. It's important to note that these agreements primarily establish rules applicable during peacetime. Protection of the marine environment during armed conflicts, and we have two primary frameworks, and the one international humanitarian law and the second international criminal law. International humanitarian law text protecting in the environment. One convention on the prohibition to the use of environmental modification techniques or military or the other offensive purposes, ENMOD, established in the aftermath of the Vietnam War. This is the only international treaty that expressly prohibits the destruction of the environment as a mean of warfare. Two Geneva Conventions and additional protocols. This international legal text signed shortly after the ENMOD directly addresses environmental protection. And three convention and protocols of the use of weapons having indiscriminate effects causing extreme suffering. Okay, this treaty seeks to regulate specific types of conventional weapons and other environmental protection through international criminal law. One, protection via the International Criminal Court, and second, crimes beyond war crimes. This is genocide or crimes against humanity. Critics of current frameworks. Recent years, states have entered numerous cooperative agreements aimed at preventing, intervening in, and minimizing marine pollution. However, many of these agreements have failed to achieve the necessary quorum for acceptance, resulting in delays and, in a few cases, in their implementation. Consequently, the anticipated progress in either addressing environmental damage during conflicts has not materialized. International law commissions draft articles on the responsibility of states for acts contrary to international law, underscores the lack of the criminal liability for the states themselves. All the individual states officials may be held accountable. Presently, the established rules are predominantly love of peace, aimed at preventing unintentional environmental damage. However, many actions resulting from wartime activities that harm to environment are intentional. Therefore, while these provisions can be applied in armed conflicts, they necessitate adaptation in address the specific challenges post-wartime conduct. International environmental law as the principal legal framework in marine pollution should be prioritizing during armed conflicts. Although direct application of these rules is often rare, with some adaptations, it may be feasible to implement them effectively to such context. Thank you for listening, us.
Thanks for that, both Ebru and Şanser, for the presentation. We'll have time for Q&A after.
Yes.
Lots of possibilities for further discussion. But in the meantime, we will shift our focus and oh, sorry, it was Evrim, not Ebru. Ebru is coming up now on state responsibility after the judgment of KLİMASENİORİNNEN. So we will hear about the European Court of Human Rights judgment from Ebru. The floor is yours.
Okay, so now I am trying to share my slides. Did I manage? Can you see the slides or?
Yes.
You can see the slides?
Very clearly.
And when I move, it is working?
Excellent.
Okay, perfect. So
everything is functioning.
Okay,
You've got it cracked.
Yeah. So hello everyone. My name is Ebru Demir, and I'm working as an assistant professor at Ankara Yıldırım Beyazıt University Faculty of Law in the International Law Department. So first of all, I would like to thank the organizers of this conference. So I'm personally benefiting and learning a lot. So many thanks İnönü Law. Today I will talk about a very significant development in the case law of the European Court of Human Rights. It happened in April, this year in April. The case VEREİN KLİMASENİORİNNEN SCHWEİZ and others against Switzerland case. This case has been the European Court of Human Rights' first case in the field of climate change, and it is the first case where the court found a violation of human rights, of the European Convention on Human Rights on a climate change case. So the case, as you can imagine, created a big impact, and it sparked many debates in human rights law and in environmental law as well. So first I will talk about the facts of the case very briefly. The case is very long, actually. It is like 260-page long case. So I'm gonna very briefly talk about the facts, and after the facts I will discuss how the European Court of Human Rights attributed state responsibility for climate change to an individual state. At the end of my presentation, I'm going to present my short analysis of the case and underline what VEREİN KLİMASENİORİNNEN case tells us regarding the responsibility of the states for the climate disaster. And also I will say a few words regarding what VEREİN tells us on the state's responsibilities for disasters such as earthquakes, which is the general theme of the conference. So in this case, we have a total of 5 applicants. In order to highlight how climate change directly affected their personal lives, the applicants focused on the effects of this problem, this climate change issue, on themselves individually. So they aim to show how climate change affected their daily lives instead of highlighting the global effects of the climate change. So the first applicant is an NGO, non-governmental organization, non-profit association called VEREİN KLİMASENİORİNNEN. The purpose of establishing this association was to reduce Switzerland's greenhouse gas emissions and the effects of these emissions on global warming. The majority of the members of this association are women over the age of 70. The association brought the application to the European Court of Human Rights and claimed that the health and daily routines of its members were affected due to the heat waves. Second applicant stated that she had difficulty withstanding heat waves and she had fainted several times when exposed to the sun on her very own property, on her own house. The second applicant stated that she had to stay at home almost all day due to the heat waves and that the temperatures triggered painful gout attacks. Also, she stated that she fainted due to the heat waves, and she presented this to the court, to the European Court of Human Rights, with a doctor's report. The third applicant told the court that heat waves had a negative impact on her life, and she had to organize her life according to the weather forecast in order to combat this. The third applicant also emphasized that she had cardiovascular health problems and stated that in her presented medical report with showing that heat waves further trigger her cardiovascular problems. Fourth applicant stated also similar issues. She said extreme heat waves aggravated her asthma and chronic lung disease. Again, she presented a medical report to the European Court of Human Rights, which shows that her health deteriorated due to the heat waves. Fifth and last applicants also underlined the disruptions in her own everyday life because of the heat waves. And she said she was unable to do the very activities that she used to do in summer months because of the heat waves. And also, again, she presented a medical report confirming that she suffered from asthma. So the applicants exhausted the domestic remedies in Switzerland. And after they brought the file before the European Court of Human Rights, and they claimed that Switzerland violated Article 2, right to life, and Article 8, right to respect for private and family life of the European Convention on Human Rights. So, as I said, the case and the judgment were examined, evaluated, and criticized from very different perspectives. But in my presentation today, I would like to focus on the state responsibility issue. And I would like to explore what VEREİN KLİMASENİORİNNEN case tells us about the state responsibility in the face of a crisis which is created by more than one country. In the face of climate crisis, how can we establish the responsible parties? Because the nature of the climate crisis is very complex, and a number of states, non-state actors, public and private institutions, individuals, groups of individuals contribute to this crisis simultaneously. So it creates an important issue regarding how to establish the responsibility under human rights law regarding the state parties' responsibilities. One of the Swiss government's objections was related to this issue. It was related to this responsibility issue. The Swiss government raised an issue concerning the proportion of the respondent states' contributions to global greenhouse gas emissions. So the government underlined that the capacity of individual states to take action and also the Swiss government questioned the responsibility of individual states for a global problem, for a global issue that in fact requires action by the community of states. The government argued that the applicants hadn't shown a clear connection between Switzerland's actions and the impact on their rights under the convention, under the European Convention on Human Rights. So the government pointed out that global warming is a worldwide issue, a global issue, and only strong actions from all countries, along with private individuals' actions, could solve this issue. So since greenhouse gas emissions come from all countries and vary between them, and since Switzerland's emissions are relatively low comparatively, Switzerland's actions alone were not enough to cause the harm claimed by the applicants. So, according to the government, there wasn't enough of a link between Switzerland's emissions and the applicants' suffering to question Switzerland's responsibilities under Articles 2 and 8 of the European Convention on Human Rights. So the state simply was trying to dismantle the causal link between the claims of the applicants and acts and omissions of the state. So as a response to the Swiss government's objections, the European Court of Human Rights in fact admitted that climate change is a global phenomenon and admitted that climate change should be addressed at the global level by the community of states. However, the European Court of Human Rights held that a respondent state should not evade its responsibility by pointing out to the responsibility of other states, whether these states are contracting parties to the European Convention on Human Rights or not. So this position is consistent, actually. It is consistent with the court's approach in cases involving a concurrent responsibility of states in case of breaches of the European Convention on Human Rights. So court in its previous cases also stated that each state can be held accountable for its share of the responsibility for the breach in question. So what can we understand from VEREİN case when it comes to state responsibility, when more than one state is responsible for an environmental crisis? So regarding the government's argument that one state's actions are just, drop in the ocean when it comes to global climate change, the court stated that it doesn't have to be proven for sure that things would have been different if the authorities had acted. So the test doesn't require showing that the harm wouldn't have happened if the authorities had done their job. So instead, the court says what is important is whether the authorities could have taken reasonable actions that could have a real chance of changing the outcome or reducing the harm. So as we know, slowly coming towards the end of my presentation, climate disaster is a universal disaster and the causes of this disaster cannot be specifically identified. There are a number of actors at international level, domestic level, regional level, and they together create this problem. So what does VEREİN tell us about the state's responsibilities in the face of a global crisis? VEREİN tells us that when more than one country contributes or causes a crisis, whether it can be a climate crisis or any other environmental crisis, States cannot hide behind the drop in the ocean excuse anymore, and they can be held responsible for their own contribution to the problem per se. Also, what does VEREİN tell us? Even though problem emerges as a result of multiple countries' acts and omissions, even if one state itself cannot cause the damage by itself, still the correlation can be established, and one state can still be found responsible, even though it did not create the consequences by itself. So it could be held responsible for its own share. So this can be also the link between my presentation and the general theme of the conference. Even if the state doesn't have direct responsibility, even if the state didn't cause the disaster itself, so we can still attribute responsibility if the steps that the state could have taken would have changed the situation, or at least mitigate the consequences. So this is what I wanted to share with you today. So thank you so much for listening, and I look forward to any questions or comments. Thank you.
Thanks so much, Ebru. A really interesting presentation that brings us up to the minute with this very significant decision, and tying it to the theme of the conference today as well. So keep your questions in mind for those of you in the audience as well as other panelists. But in the meantime, let's turn to our final panelist, Nazia. The floor is yours. We'll need your mute to go off.
Let me try if I can share. If I cannot, I'm not gonna try. So let's see, because I have. Did I manage to do that?
No.
Okay. So, okay, let's skip that bit because I don't think I can manage to share my presentation. Let's not spend some time on that, and then let's continue. Okay, then. So I'm a lecturer in international law. Hello, everybody. I'm working at Sakarya University, and I would like to thank the conference organizers for this, quite important subject of our recent times. As internal displacement was already covered by Matthew, actually, I was quite happy because now I can further discuss on environmental displaced phenomenon at international level. Because the environmental displacement phenomenon actually has two main issues. One, there is no international legally binding document dedicated to their protection. Second, actually, there is no internationally agreed term on what is an environmental displaced people, because are they the ones who cross borders? Are they the ones who do not cross borders, or how they are going to protect it are the main subjects. However, my point here with relation with the cases, environmental cases, I am quite curious. Actually, I was quite curious before I started to do this analysis. Are those courts, either domestic, international, and regional courts, refer environmentally displaced people's stations or environmental displacement at some parts of their court decisions, and how they are deal with this case? Because as we have some sort of protection issues and definitional issues, so is there some sort of side that I could find in those judicial or litigation decisions? The United Nations actually formally do not endorse the use of environmental refugees because referring them as refugee might lead them to another different protection regime. So it might maybe influence the understanding or interpretation of the Refugee Convention itself. So In 2007, UNHCR, United Nations High Commissioner for Refugees, made some sort of definition about environmental displacement and those people. Word by word, they mentioned people who are displaced from and who feel obliged to leave their usual place of residence because their lives, their livelihoods, welfare have been placed at risk as a result of adverse environmental, ecological, and climatic processes and events. Actually, there are two things highlighting here. This movement is forced movement, so they're not voluntarily moving. So they have it's an involuntary movement. The other one is actually the maybe the main highlight of the definition. People feel at serious risk. So, is there any connection that can be made in their protection under Refugee Convention? Is another subject to discuss. However, when there's like some sort of protection gaps emerge, some independent experts referred to Human Rights Council and maybe ask them prepare some sort of resolution submission to the General Assembly, and there might be some sort of optional protocol can be produced under the Refugee Convention, 1951 Refugee Convention. If it is feasible or doable, this is also another discussion, but this shows that actually there's a quite greater need how we should protect those people. So that was my starting point. So how we should refer their rights or their protection. And I started to dig in some domestic litigations, and actually the picture is quite varied at domestic litigations. For example, in total, when I look at the global climate change litigation data, I saw more than 150 cases related to environmental aspects. Among them, 7 of them highly related with the migration. And in those cases, many different aspects were actually analyzed. For example, one case was on the applicants, whether the applicant can be, get their visa, and is the country owed protection from the sea level rise under the Migration Act of Australia and Refugee Convention. The other case is dealing with whether climate change focused asylum can be granted to those people in USA. So they took more or less the same view here. They said that actually the Refugee Convention itself do not protect those people in terms of definition, because there's an element of persecution is missing here. So the wording of the court is like that. It says that continued production of carbon emissions that might cause climate change, but this climate change is not sufficient to constitute persecution under Refugee Convention. Therefore, the protection should not be granted. So in US law, they also follow the same logic, and they say that the climate change should not lead or reach the threshold of persecution within the meanings of US migration law. So the domestic understanding that granting some sort of protection to those people at as an international level is somehow a little bit like on the side. However, there are some sort of other examples which took in Italy, which is about if humanitarian protection can be granted to those people who are directly influenced by the climate change, and if it exposed a real risk to their right to life in their country of origin. So now the aspect is going from the human rights aspect. What happens if their human rights are violated, or what happens if we approach their protection through the human rights aspect? So the court here, the Italian Supreme Court here, actually says that humanitarian protection must be granted according to the assessment of climate change and influences on adverse influences on the populations, and the situation in the country of origin does not allow for a minimum essential limit of guarantee for the right to life of those individuals. So actually here we see that the human rights protection aspect on the protection of environmentally displaced people is a more direct and maybe more feasible approach to provide some sort of protection to those. One less domestic litigation has happened in Colombia. Colombian Constitutional Court approached the climate change and displacement issue through the internal displacement contact, and the applicants were seeking an answer if they are included as internal displaced people as a result of environmental factors, because Colombian IDP law, actually Colombian internal displacement law, do not include people who are forced to flee as a result of environmental displaced people. So actually the court took quite a broad interpretation and mentioned that even if the law itself do not include specific environmental displaced people's protection, this does not preclude environmental authorities not to provide protection and assistance or relocation of these people. So they said that because these standards comes from the international standards, even if it is not, even if there is some sort of legal gap inside the Colombian legal system. So this explains, maybe we should understand environmental displaced people from a broader perspective. This opens some sort of doors for us. However, as you may see, there are like some sort of differing views at domestic level. So maybe understanding if there is some sort of decisions at international level from the international judicial bodies or some sort of international, committees, human rights committees, if they can set some sort of standard in the evaluation and interpretation of climate change, human rights protection, and displacement. So I have looked some of the cases. There are 3 outstanding events, or maybe, I don't know, things happening at international level. The first one is the ICJ's advisory opinion on the climate change and state responsibility. The advisory opinion has not been delivered yet. Hopefully it will be reviewed, I think, in the first half of 2025. All the hearings were completed. We're following it. Of course, my focus here is the displacement aspect going to be included in their advisory opinion? Or if it is included, how it is going to be addressed? Because there is some sort of questions which can be displacement related, and for give them some sort of opportunity interpret border, because the question, for example, one of the questions that is asked from the states to ICJ is there any state responsibility on peoples and individuals of the present and future generations affected by the adverse effects of climate change? So, as I mentioned, maybe ICJ has not been asked to opine directly on the issue of the legal implications of displacement. However, this does not actually preclude ICJ itself to sufficiently or enable itself to address the climate change and some human mobilities in a more explicit way to understand how to avert or minimize and address displacement. So we're going to see, hopefully in the next couple of months. So there is another international decision took place, which is, this is directly displacement related, is given by the Human Rights Committee. We know that Human Rights Committee's decisions might not be legally binding, but it provides a really good standard of understanding how should we approach environmental displaced people in international area, even and in national policies. The case was actually analyzed of the New Zealand case, and the people the applicant here do not want to deport it by the country because they said that they might face some sort of dire stations in their own country, which has highly influenced by the climate change, and they might risk some sort of, they might face some sort of conflict there. So even if the applicant themselves did not mention the displacement aspect, the court actually, the committee actually, in its decision, make some sort of connection between climate change and displacement, and said that there is a violation of Article 6, right to life, from International Covenant on Civil and Political Rights, Article 7, prohibition of torture and cruel and inhuman treatment. And the committee also mentions that actually those violations might give some sort of responsibilities for a country to protect those people. This can even trigger some sort of aspects of principle of non-refoulement, obligations of a standing state. So it goes quite a broad one, and even triggers the application of principle of non-refoulement. So that's a quite broad interpretation of displacement from a climate change base. The other one is advisory opinion that has been revealed in May by the International Tribunal of Law of the Sea. So again, the advisory opinion was requested about what is going to happen in the chains of climate change to the marine pollution. So obviously the focus was about marine pollution, but my point here, if I have checked 150 pages of the advisory opinion, if displacement has taken place or were referred at some parts of this decision, because if it is included, at least referred in this decision, this can be understood, or maybe it is my positive perspective, this can be understood as displacement or environmental displacement, something that cannot be ignored, because those people do not only displaced in land, they also feel the displacement at sea. So they made a small reference, which is expected, as I said, about their focus. Their focus was marine pollution. However, they also refer displacement, something like this: climate hazards are a growing driver of involuntary migration and displacement, and that climate-related illnesses might threaten people's rights. And concludes that the tribunal, climate change represents an existential threat and raises human rights concerns. So now we can see that actually international judicial bodies can also refer environmental displacement as the subject that needs to be touched upon. In regional level, there is one more advisory opinion is upcoming from Inter-American Court of Human Rights. So we will see the outcomes of it. So I'm not going to go in detail of that. In African Court of Human Rights,
you have 1 minute, Nazia.
Okay. There is no more. I mean, there is no cases has been brought to the court. And in European Court of Human Rights, actually there have been 12 cases has been brought, but some of them were admissible, some of them were adjourned, and one of them has been decided in April, which were already covered by the previous presentation. However, my point is, if the displacement was also included in this decision, the answer is yes. It was also addressed by the European Court of Human Rights as a state responsibility to find durable solutions to those who are adversely affect environmental aspects or environmental crisis for those people. Okay, this is all I have to say. Thanks for listening. The floor is yours, Matthew.
Thanks, Nazia. Now we've had 4 presentations covering a variety of topics. The floor is open if people have questions. I'll pause for a second. I've got questions for all the panelists, but I can start asking them. I'm not sure I know Google Meet so well. Can you raise your hand if you have a question? Yes, it looks like it. So if you do have a question or a reflection, please do raise your hand and I'll call on you. In the meantime, I can, and maybe we can do, we've got about 10 minutes, we can do a round of questions. So I could put a question to each of the panelists if others are thinking. Of course, we're 4 panelists, so if anyone's got any questions for me, I can field those as well, but don't feel obliged. So from my point of view, I found the first presentation by Evrim and Şanser really stimulating, connecting two kind of complex issues around the rights of nature and the humanitarian law issue, and the international criminal law point. And I don't think I heard the word ecocide used, but I wonder, since there was reference to this international criminal law dimension, if the authors or the panelists there think that there's some potential for that emergent concept to make an impact. Similarly, with the recently recognized right to a healthy environment, if these kind of principles could do more to advance environmental protection in this maritime context that you're focusing on. So that's one question. Don't let me monologue. If you've got questions, please jump in. But I've got another one, which is for Ebru, relating to KLİMASENİORİNNEN. And the final thing that you were saying, Ebru, about the relevance of KLİMASENİORİNNEN for earthquake contexts and the responsibility of the state to take steps to address foreseeable harm. And it made me think about the Budayeva case as well, which is Budayeva against the Russian Federation, decided sometime in the early 2000s about a mudslide in the southern Caucasus region of Tirnauz, where there was a violation of the right to life found, and also the Öner Yildiz against Turkey case. Both of these seem to point in the same direction, and I wonder if the KLİMASENİORİNNEN adds another dimension to that, and if so, how? And finally, for Nazia, I was very interested in this case-based approach, and I think this is a really important way to get really more granular understanding of how international law in its different forms applies in the context of whether cross-border or internal climate-related displacement. We should see much more of that case-based analysis because it helps us to move beyond the hypothetical. And we see a lot of hypothetical in this space, especially with estimates of 50 million climate refugees or this kind of numbers on the back of an envelope stuff. So looking at concrete cases is good, and there are more of them now. So that's excellent. I thought about, I suppose it was a question about sources. And I think you mentioned 150 cases. Did you find them in a particular place? And this is also an opportunity for me to flag the CLIMIG law database, which is emerging, which is beta version. So if you've seen it, forgive all of the glitches. We're getting there. But anyway, those are 3 questions to the 4 panelists. Well, the 4 minus me. Over to you. We'll take it in order. And then if you're in the audience or panelists and have other questions, put your hand up and we can take another round, I think, if we have time. So that means the floor goes to Evrim and Şanser first.
I will start first. We conduct a study, especially on the seas, but we tried develop a perspective from which we could say something in terms of environmental law and international law. Yeah, we actually limit the study in this way because it's very, very large. But because we want to do something outside of the unusual studies about Turkey, we want to look at it from this different perspective. Nowadays, we did not want to example or specific word because we want to look at from a general perspective. In my verses, yes, Evrim.
Thank you. Also, I just want to add this one. We are not saying we have this critical point and ecocide you said, but it's a debatable concept. We have this perspective, critical law perspective, but we are not saying that law is completely useless. Of course not. I'm also a lawyer, but we must first acknowledge it. We have to know its limitations. The key questions here is what are the reasons for these limitations? Which ones can be changed within the law and which outside the law or outside the law? Because we cannot shape the world just by just law itself. There are environmental laws and, for example, about your subject, climate regulations. We have lots of them. International mechanisms, but the world is getting hotter every year and people are being displaced more and more. So we have to find solutions both within law and outside the law. Okay.
So thank you so much for the question. You can hear me? Okay, perfect. So thank you so much for the question regarding the Russian case. I am aware of, and Öner Yıldız from Turkey I am aware of, and also there is directly a case from the European Court of Human Rights jurisprudence regarding the earthquake, which is Özel and others against Turkey case directly related to earthquake actually, where again European Court of Human Rights finds the states responsible. So compared to, I think I was expecting this question, compared to the previous jurisprudence, what VEREİN case is adding when it comes to state responsibility, I think what is new is, first of all, in the, of course, climate disaster context, it's a different context from the jurisprudence existing. We have multiple responsibles in this issue, and the court says they can be held responsible individually. So the crisis that we are talking about, I mean, the climate crisis can only occur with the contributions of multiple parties. So it is hard to address who is responsible in this case. So I can say if there are more than one contributor, if a state is claiming that there are other parties also responsible for this, and I'm a drop in the ocean argument. So this case, this argument is not valid in my understanding of the VEREİN. So in terms of state responsibility, I agree it is not adding a completely new understanding, but I think it is strengthening and enforcing the court's approach in terms of state responsibility, which is already existing. So it is just strengthening, I can say. So thank you so much for
I did see that. I think it's I think there's room to look further even if it takes it one, maybe even around the multiplicity of actors. If you think about an earthquake situation and there's building regulations and there's local authorities and there's all kinds of complexities there, maybe more so than in a mudslide. So it triggers thinking.
Yeah,
thanks.
that's good. That's good to hear. Thank you so much again.
Great. Okay, thanks. Nazia?
Yeah, Matthew, I think I agree with you because the case-based approach in this sort of vague parts of human rights protection and people's movements actually could provide some sort of solid base. So this is actually most of the times what I have done and what I'm gonna do. I really like to case bases at domestic level, international level, and regional level, and there are more to come. Most of the decisions, actually, the decisions I was included was the decided ones. Most of them, some of them are pending, some of them are, found inadmissible, and so on. And there's some sort of database that I can share with you. I can email you about climate litigation. But most of the times, I also follow the yearly reports of UN committee and some other organs. But yes, I will email you the database. That would help, I think, for you to maybe find some sort of maybe some solid answers in the stations.
Sorry, I went mute. Yeah, great. Thank you. Thanks for that. Well, we've come to 12:30, which is our designated concluding point in time. So probably we don't do another round, but we can at least thank all of the panelists for the presentation and the organizers once again for bringing us together to have this conversation, hopefully just the starting point, and wishing you all a good further conference as the day unfolds. So until next time.
Thank you.
Thank you so
Bye.
much.
Bye-bye. Thanks.
Bye.